The law doesn't require you to be drunk to get a DUI. It just requires you to make one of these 6 mistakes. Right now, police departments across the country are training officers in 6 specific, documented tactics that are designed to build a DUI case against you, regardless of whether you've had a single drink. These aren't conspiracy theories. They're in the training manuals. They're on the body cam footage. They're in the court records. And almost no one knows about them until it's too late. I've spent years analyzing DUI case files, police training documentation, and body cam footage from stops across all 50 states. What I found is that the same 6 tactics appear over and over, in case after case of innocent drivers who did everything wrong simply because they didn't know what was actually happening during the stop. I'm going to walk you through all 6, break down the legal reality behind each one, and tell you exactly what protects you. Stay until the end, because the last one is the one that destroys cases that should have been won. Before we get into it, hit subscribe right now. Every week on this channel I put out the legal knowledge that most people only learn after they've already needed it. Hit the bell so you're notified every time a new video drops. Now let's get into the 6 tactics. Tactic number 1, the casual opener. Officers are now trained to open traffic stops with friendly, conversational questions before they ever ask for your documents. How's your night going? Where are you coming from? Long day? It sounds like small talk. It is a structured interrogation technique, and it starts the moment they reach your window. Every answer you give during a traffic stop is recorded, documented, and can be used as evidence. When you say you're tired, you've just given the officer grounds to investigate fatigue impairment, which is prosecuted identically to alcohol impairment in most states. When you say you came from a bar district, you've established location-based context that goes into the report. There is no part of the conversation that is off the record. Prosecutors are skilled at taking ordinary language and framing it as evidence of impairment. A casual "I'm just exhausted" becomes documented evidence of cognitive impairment. A mention of being out late becomes evidence of a night of drinking. The officer isn't making casual conversation. They're building the foundation of a case file, and your words are the materials. Training manuals teach officers that most drivers will talk. The social pressure to answer a friendly question feels overwhelming in the moment, especially when you believe you have nothing to hide. Officers are trained to exploit that instinct, to keep the conversation flowing naturally until you've given them enough to work with. By the time you realize what's happening, the report has already been written in your mind. Tactic number 2, the document retrieval observation window. Officers are trained to request your license and registration early in the stop, not primarily because they need the documents immediately, but because watching you retrieve them gives them a structured window to observe your coordination, your fine motor control, your eye movement, and your ability to follow a 2-part instruction under mild stress. Everything observable during a traffic stop is admissible. An officer can legally know that you fumbled through your glove box, that your hands appeared unsteady, that you handed over the wrong document first, or that you needed multiple attempts to separate your license from your wallet. None of these things prove impairment. All of them become documented as impairment indicators in a trained officer's report. Police report language is trained and standardized. Phrases like exhibited difficulty locating documents, demonstrated unsteady fine motor movements, and required additional time to produce requested materials are designed to read as impairment indicators to prosecutors and juries, even when the driver was simply nervous, had a disorganized wallet, or was dealing with a new vehicle. Context disappears. The language stays. Officers understand that nervousness and disorganization are normal human responses to being pulled over. They're trained not to factor that in. The observation window during document retrieval is valuable precisely because most people don't realize they're being assessed. They're focused on finding their registration. The officer is focused on their hands. Tactic number 3. The HGNI test. The horizontal gaze nystagmus test is where an officer moves a pen or light horizontally in front of your eyes and watches for involuntary jerking movements. They present it in medical, clinical language. I just need to check your eyes. And most people comply without realizing this test is entirely voluntary and has an accuracy rate the officer will never tell you about. NHTSA's own research puts the HGN test at 77% accuracy for identifying alcohol impairment. That means it produces incorrect results nearly 1 out of every 4 times. More importantly, nystagmus, the involuntary eye movement the test looks for, is triggered by over 40 documented medical conditions and common medications that have nothing to do with alcohol. Antihistamines, inner ear disorders, blood pressure medication, high caffeine intake. All of these can produce a positive result on a test the officer is describing as definitive. Unlike a breathalyzer, HGN results cannot be challenged with a retest. Once an officer writes exhibited 4 out of 6 nystagmus clues in an arrest report, that language is locked in. Defense attorneys can challenge the method, but juries hear eye test and think science. They don't hear coin flip accuracy rate and 40 other causes. The documentation outlasts the context. Officers administer HGN before any other test because it creates an early documented clue that colors everything that follows. If the eye test is in the report, the rest of the investigation reads as confirmation. They're also trained to frame it in health language rather than legal language, checking your eyes rather than conducting a sobriety assessment, because health language generates compliance. Most people don't refuse a health check. Tactic number 4. The walk and turn and one-leg stand performance trap. Field sobriety tests, walk and turn, one-leg stand, the classics, are presented as standard procedure. Officers say they need you to perform them, using language that implies legal requirement. They are not legally required. They are voluntary. And they are specifically calibrated to produce failure documentation regardless of the driver's actual impairment level. NHTSA's research shows walk and turn correctly identifies impairment 68% of the time, and one-leg stand 65% of the time. A coin flip is 50%. These tests fail to correctly clear sober drivers more than 1/3 of the time. Sober people fail them from nervousness, physical conditions, poor lighting, uneven pavement, improper instructions, or simple miscounting by the officer. Every stumble, every foot placement, every hesitation is counted as a failure clue. There is no partial credit for sober behavior. Body cameras capture performance, but rarely capture the conditions under which the test was administered. They don't show that the instructions were rushed, that the ground was sloped, that the driver has a previous knee injury, or that the officer miscounted the steps. Juries see footage of someone struggling to walk a line, and they draw the obvious conclusion. Defense attorneys call this the performance trap because there is no outcome that reliably helps you, only outcomes that hurt you in varying degrees. Officers are trained to phrase the test as a command rather than a request. Step out and perform some tests is the standard language, not would you be willing to perform some tests. The framing matters. Most people step out and comply because they believe refusal implies guilt. Training manuals document this as the primary reason voluntary compliance rates are high. The implication of guilt is a feature of the technique, not a side effect. Tactic number 5. The pre-arrest roadside breath test. The officer produces a small handheld device and tells you to blow into it. Most drivers think this is the breathalyzer, the official test. It is not. This is a preliminary alcohol screening device, a PS test, and it is legally and procedurally different from the evidentiary breath test administered at the station after arrest. Most people don't know the difference. Officers count on that. The PAS test is voluntary for drivers over 21 in most states. It is not covered by implied consent law. It is not admissible in court as direct blood alcohol evidence. It exists for one purpose: to establish probable cause for arrest. These portable devices are not calibrated to the same standard as station breathalyzers. They produce false positives from mouth alcohol, acid reflux, mouthwash, and low temperatures. They are screening tools, not evidentiary instruments, and yet officers present them as if the result settles the question. Even a result well below the legal limit gets documented as subject registered positive for the presence of alcohol. Prosecutors use that language. The actual number may not be admissible, but the positive detection becomes part of the probable cause narrative. Drivers who blow a 0.02 and expect to go home instead find that number cited in the arrest report as evidence that they had been drinking. They gave away probable cause for nothing. Officers are trained to present the PS test as if it is mandatory, or as if it is the thing that will get you sent home. Both framings are misleading. Implied consent laws require chemical testing after a lawful arrest, not before one. The pre-arrest roadside test is voluntary. The officer's goal is to get a result, any result, that justifies the arrest they're building toward. A 0 clears you and ends the stop. Anything above 0 stays in the report regardless of what it means legally. Tactic number 6. The post-arrest conversation. You've been arrested. You are at the station. A different officer, often a calmer, friendlier one, sits across from you and begins talking. Not interrogating. Talking. Explaining the situation. Asking casual questions. Suggesting that explaining your side of things will help. This is the most dangerous moment of the entire encounter, and it is where the most cases are lost. Miranda rights apply once you are in custody and being interrogated. But the Supreme Court's ruling in Burgess v. Tompkins established a critical detail most people don't know. Simply remaining silent is not enough to invoke your right to silence. You must explicitly state that you are invoking it. If you sit quietly without saying the words, statements you eventually make are admissible. The right exists, but it only activates when you say so. Post-arrest statements become the prosecution's centerpiece. A driver who says they only had one drink 3 hours ago hands prosecutors a toxicologist's testimony, a counter-narrative about minimizing consumption, and a documented connection between the driver and alcohol on the night in question. Trying to appear cooperative after arrest does not result in cooperative treatment. It results in more evidence for the prosecution. Post-arrest interrogation training is sophisticated. Officers are trained to minimize the situation, to suggest that honesty leads to better outcomes, that the judge responds favorably to cooperation, that they're just trying to understand what happened. None of it changes the reality that every word said in that room is recorded and handed to a prosecutor whose job is to convict. The friendly post-arrest conversation is not an off-ramp. It is a continuation of the evidence collection process. Building a DUI case is a process. It requires a chain of evidence, statements, observations, test results, admissions, and every link in that chain requires your voluntary participation. Officers are not simply observing what's happening. They are systematically creating opportunities for you to build the case against yourself. Every time you decline to add a link to that chain, you force the prosecution to work with only what they can objectively prove without your help. You don't have to be confrontational. You don't have to be hostile. You simply have to understand what's actually being asked of you and exercise the rights that already exist to protect you. If this video gave you knowledge you didn't have before, subscribe to this channel right now. Every single week I publish videos on your rights, what the law actually says, how it actually works, and exactly how to use it when it counts. Hit subscribe, hit the bell, and share this with everyone you know who drives, because these 6 tactics are happening every day to people who had no idea what was coming. Now you do. Stay informed. Stay protected.